Yes! Hello, my beautiful friends. What an amazing day it is. Welcome back. We've got some big updates that are percolating out there today. 2 dismissals of some big cases. Of course, one of the biggest of all the cases, the Big Tish case. Letitia James and James Comey both got orders of dismissal today. Dang. But what does this mean exactly? Are they going to stay dismissed? We got our doubts about that. So we're going to break it down today. I've got the orders queued up here. Quick preview on what we're getting into. Then we'll circle back around and zoom in for further detail. But you see this one came down 29 pages in conjunction with this one, which is different, but very similar in the Letitia James case. So Comey and Letitia both got their cases dismissed by this judge, as you can see over here. Her name is Judge Cameron McGowan Cury over here on the right. And what's interesting about this is she's a Clinton appointee, which is curious because James Comey was, in our opinion, committing crimes in order to elect Hillary Clinton. Remember that back in 2016, the subject of all these charges. So we'll go through this. We'll see what the latest is on the Comey and the Letitia case. We had James Comey himself come out today and release a ridiculous little video like this, way too close to the camera as usual. But he is saying that, he's probably going to get indicted again or something might be coming back down. He is doing a little bit of a victory lap, but there is some trepidation in the voice. So we'll listen to that. And then Caroline Levin was out today a couple times with a couple of clips explaining that they are going to be appealing this and they are going to be standing by Lindsay Halligan. So we got a couple of clips queued up for reaction on this, and we're excited to get into it because there's a lot of headlines out there, case dismissed, and you see the headlines, and even myself, I'm like, but it's a very technical dismissal, and I think the judge is dead wrong. So we'll explain exactly what's going on. Then we've got an update on the Bill and Hillary subpoenas. They were supposed to be in Congress being deposed about Bill Clinton's trip over with Jeffrey, and they never showed up. So now the question is, since they've gotten valid subpoenas and they are not abiding by them, maybe they should be referred over for contempt and prosecuted and thrown in prison, just like Bannon and Navarro were. And they could even share a cell. Save on costs. But we got Comer now sending a letter to their lawyer. Came out over the weekend. He says, hey, this is our final warning. You better get in here. All right. And we've scheduled new dates for your booties to get in here right before Christmas. So cancel your trips to the Virgin Islands, Bill. You're coming into Congress in December. So we'll see what the latest is there. And we also saw that the DOJ, now pursuant to the new law that says release the records, that they have submitted another attempt to unseal the grand jury transcripts and the grand jury records from Epstein's cases. This one's in the Southern District of Florida. We got a lot of questions about this case. So we'll see what they are asking for. They've already, we've covered it here, said, please release the records. They're like, will you please release them? The judge is like, no. They're like, okay, bye. And they just left. But now we've got congressional stamp of approval on this. So we'll see if they're able to get anything peering out. And then lastly, we'll see what's going on with our seditious senators, the Seditious Six, because the Department of War has now come out and has explained that they're investigating Mark Kelly, the senator from Arizona, who was part of that video, basically insurrecting our military. So they have said that they're going to be investigating him. Lots of Reactions to this. Pete Hegseth came out and also posted about it. We've got Captain Mark Kelly, who's responding to this. They all went out over the weekend and they're like, well, we were just talking metaphorically. We were talking in theatrical terms. It wasn't anything that we actually meant about illegal orders because they couldn't even name one and identify one. So we'll catch the latest on this one as well. And it is a beautiful day, my friends. Not as beautiful as normal because we've got 2 criminals who are at least temporarily escaping indictment today. But this morning, we had a great members only stream. We talked about a bunch of amazing things that we only talk about on the members only streams. And so we'd love to have you come join us as a membo. If you want to grab some extra content, meet some amazing people and support our work here. Becoming a membo is a great way to do it. And we really appreciate you making what we do here possible. And we thank you for being a part of our community. Membos, we love you. All right, so, and thanks for subscribing to our channel if you haven't already done that as well. We appreciate that too. And thanks for being here. Happy Monday. It's Thanksgiving week. Hopefully your appetites are warming up. All right, now, let's get into the business on the day. The tubes are nice and warm, hopefully coming in loud and clear. All right, let's get to it. We've got a couple of cases to talk about, and here we go. Letitia James and James Comey, both popping champagne bottles today. Their cases have been dismissed, but that might be a bit premature. Still a long road ahead for both of them. We've got these orders that came down from a Clinton-appointed judge in both of these cases, the James Comey case, and you can see this one looks almost identical, the Letitia James case, both coming out of the Eastern District of Virginia, and they're both orders granting the motions to dismiss. Now, it's a very technical explanation by this judge for why Lindsay Halligan is not allowed to bring these prosecutions, but it's so narrow that this leaves us with a couple of options. First of all, we can appeal this and see what the Fourth Circuit says, whether they would say, actually, this judge's interpretation of the law is wrong and bring these indictments right back, or, as I think we'll see as we go through this and hopefully can tease out with the judge's language, there's another option as well. If we do not want to appeal Lindsay Halligan's role, maybe we just assign another special attorney to come in and take the case over and prosecute them anyways. And we've got a 6-month window in which we can do that. We'll break it all down. But reaction to this, of course, Caroline Leavitt is out and they're saying that they're going to be appealing this or working through whatever the next steps are. We've got those clips coming up. We'll save those to the end. But here is what the latest is. So we saw this come down in both cases and they're essentially the same. So we'll go with James Comey's case here. And you'll notice it says here from the judge, before we get into the substance, that it's the same judge. So scrolling all the way down in the James Comey document, the order that just came down, you see the judge's name down here is called Cameron McGowan Cury. That's on the Comey case. Same judge over here. All the way at the bottom of the Letitia case, scroll all the way down here, it's the same judge. Cameron McGowan Cury. And how did we get in front of this judge? Well, you remember that it got assigned over to her right here. Lindsay Halligan is the U.S. attorney who has now just been basically disqualified. We'll see that she, I think, has a little bit life left in her yet. Don't write her off so quickly because I think this judge is wrong. But the judge over here is the judge, Cameron McGowan Cury. And she got handed both of these cases to settle this issue after some interesting things happened. So first of all, it was assigned to her from another judge, this judge, called Fourth Circuit Court of Appeals, the chief judge called Albert Diaz. Who is Albert Diaz? He is an Obama appointee. So he takes the case and he says, wow, we might have to disqualify a U.S. attorney. This is a big deal. So I can't let the case judge handle it. So we're going to assign it to some other judge to handle it to decide whether or not we can disqualify Lindsay. So he gives it over to her. So an Obama judge hands it off to Judge Cury. Judge Cury was appointed by Bill Clinton. Bill Clinton, of course, is married to Hillary Clinton, and James Comey was operating on behalf of Hillary Clinton. In his emails, he said that President-elect Clinton, Hillary's really going to like what we've done here because we've aired all this out, and all of the evidence of her deleted emails that they found on the Wiener laptop that got turned over after Comey testified to Congress that Hillary didn't deserve charges, she would be happy that that's not going to drag around and impede her during her first term. Comey was operating on behalf of Clinton. Now a Clinton-appointed judge is going to protect Comey. See how that works? All just one big disgusting incestuous family over there. So that's the judge. She's the one who's presiding over this, and she's pretty ancient. She's been around forever. Don't even have a photo of her over on the Wikipedia, but she was appointed by Bill Clinton. She's 77, was over at senior status, and just got conveniently handed this case that's going to dump 2 cases against Democrat hacks. So here's what she wrote, and we're going to use her own opinion against her, essentially, to read through what the options are and why I think that this is such a narrow and a limited holding that it's ripe for reversal. So all of the celebration Letitia James probably called Fannie Willis. She's like, we're going on a cruise. Call Nathan. Hold off on that, Letish. You might be coming back to court sooner than you think. So these are essentially the same. We've got some differences between the two because of charges. Of course, Comey was charged with obstruction and lying to Congress. Tish, mortgage fraud. We also have a statute of limitations problem, which is much more significant in the Comey case because his statute of limitations is already expired. His crimes that he was charged with were lying to Congress back September 2020. So 5 years elapsed. Boom, clock runs out. That's going to come back in this one significantly, whereas in the Letish case, not as much of an issue. So here's what the judge writes. All right. On September 25th, Lindsay Halligan, a former White House aide with no prior prosecutorial experience. So what? That's just opinionated, slanderous type of attacks from this judge. She appeared before a federal grand jury and having been appointed, these words are key, interim U.S. attorney just days before, she came and got a 2-count indictment in front of Comey for making false statements and obstructing a congressional proceeding for being a liar. We've looked at his emails. This dude is as dirty as it gets. And now he's going to be celebrating the escape of this fleeting prosecution. Now, Mr. Comey now moves to dismiss the indictment. He says Lindsay, the sole prosecutor who presented to the case, was unlawfully appointed in violation of 28 U.S. Code Section 546. Okay, so these numbers, we're going to do our best to keep track of them, but 546 is the appointment power for Halligan. 546. She says, okay, as I agree, I'm going to explain below, the judge says, I think that was invalid. And it's all going to hang on an interpretation of this statute, right? Which I think she's wrong on, as we'll look at. And because Ms. Halligan had no lawful authority to present the indictment, I'm going to grant Comey's motion to dismiss. Letitia's also got dumped on the same basis. But as you'll notice here, it says without prejudice, which means they can come back again and file it again. It's not done. This case is just done, but you can bring it back. Now, we know, and we're going to come back to this a lot because the appointments clause, it is part of the executive branch. The text of the clause says that there's 2 types of officers. Article 2, okay, that's the executive. It says you can appoint people, inferior and officers, and there's all these rules about it. Now, for the United States attorneys, Congress has preserved the default rule. Okay, for U.S. attorneys, we know, we've been through many of them. President appoints them, the Senate confirms them. That gives us a lawful U.S. attorney, giving us the rules there. And then we have the code, okay, 28 U.S. code. So the Constitution, then Congress comes in, they explain what the Constitution means and enables. They pass this statute, Section 546, which is what Lindsay Halligan used. And the judge is going to scream about this and say you used it inappropriately. Section 546, judge writes, essentially divides the responsibility for making interim appointments between the AG and the district courts. So if you don't have an official U.S. attorney, like in other words, Lindsay Halligan, as we remember, she has been appointed, but she has not been Senate confirmed. So that equation has not been satisfied yet. So what happens in a situation where we don't have that completed? The law, Section 546, which Halligan relied on, it explains. Now, the AG may appoint a U.S. attorney for the district in which the office is vacant. Okay, pretty simple. Vacant U.S. attorney, office, Pam Bondi can make the appointment. Now, if the Senate refused to allow that person through, you can't put that person in there, all right? A person appointed under the section may serve until the earlier of one of these two. One, some other U.S. attorney comes in. So you have this person sitting in the seat until an official confirmed person can come and take the seat. Or 120 days expires, right? So we're several cycles into the president right now. We're in November. So we've had several 120-day periods come through. And they explain, you get 120 days. You can sit there for 120 days. Now, if an appointment expires under this section, so we're in this section C2 right now, with Lindsay Halligan, and she had a prior U.S. attorney in there before who expired. If 120 days expire, this says, comma, the district court for such a district may appoint a U.S. attorney to serve until the vacancy is filled. You see that right there? That may word, pretty important word. The order of appointment by the court shall be filed with the clerk of the court. So if the seat is empty, the court may appoint a U.S. attorney. And what the judge is going to say is that in other words, we appoint somebody. We should have replaced the person who's in Lindsay Halligan's seat. The DOJ doesn't have the ability to fill that seat. And again, it's may. And we've gone through this a bunch, right? If it shall, then it's mandatory. It's you have this responsibility, court. But may, in our interpretation, is discretionary. You can do it or not. If the seat is empty and the DOJ, for example, the executive branch is not filling it, then the district court may go find somebody and fill the seat. We don't want empty seats. So if the DOJ is dropping the ball and they don't have somebody in the seat prosecuting these cases, the district court can go and do that. But it's not only the district court can do this, or the district court shall do this, or this is exclusionary to the executive branch at all. Remember that the appointment power is back in Article 2. That's the executive power. So why would we just shift that away? In other words, you get one option at appointing somebody, otherwise you lose it after your 120 days. Then the court just gets the appointment power under Article 2. That makes no sense at all. Now, they continue. Judge writes, so, I mean, just interpret that, right? Just thinking about that, exactly how this statute works, just logically. It means, okay, so if the AG cannot appoint anybody, then the courts, you get one shot, 120 days, and then it reverts all of those constitutional powers to the courts. Are you out of your mind? It makes no sense. So we'll explain more. Now, on January 20th, Jessica Aber, who had been nominated by Joe Biden and confirmed by the Senate, she got out of there. She resigned. Good riddance to Jessica. The following day, the Attorney General then appointed Eric Siebert. Pam Bondi comes in, January 21. Jessica's out. Eric comes in, appoints him under Section 546, the section that we just read. He was there for 120 days, and it was set to expire on May 21st. So on May 9th, the judges of the district exercised their authority and they appointed Siebert to continue the role. That was effective May 21. So they came in, they said, you're back up. Eric, you're about to expire. We like you. We're going to keep you here. Then on September 19th, Siebert informed colleagues he was resigning. He's out. According to news reports, Siebert had recently expressed concerns to DOJ officials about the viability of going after Comey. Eric, pathetic. And Tish. He's like, I can't find any evidence. I don't know where the evidence is. We've seen it in Comey's emails. Eric, did you not read the emails that were in the file? Did you even look at it? Because we've seen it. We've seen it all. Lindsay Halligan dumped a bunch of them on the docket for all of us to read. So Eric, were you just incompetent or were you partisan and biased and you didn't want to go investigate these criminal defendants, which is your job? Anyway, Siebert, his resignation came hours after Trump told reporters that he wanted Siebert out, which is a good call. Should have happened a long time ago. Pam Bondi should have identified this person and gotten rid of them a long time ago. Not waiting until, if anybody's going to be criticized here, it's this. Why are we waiting until September 19th to make this happen? Comey's statute of limitations expires on September 30th. Waiting till the last minute. Then Lindsay Halligan comes in. Then Trump posted this. He says, Pam, the hell is going on over there? We've read this many times. He says, will you do your job now? Justice must be served now. President Trump, go do it. Less than 48 hours after Trump made a good post about this and Pam woke up probably in cold sweats and then went back to bed without indicting anybody, the Attorney General issued an order. And the order appointing Lindsay came in and said Lindsay Halligan is going to be the interim U.S. attorney. And again, under this provision, 546, which is just what we talked about, the 120-day interim attorney rule. Now, Eric Siebert has already been in there. So he says, I can't find any evidence of this. This feels egregious. He leaves. Halligan comes in and says, are you stupid? Look at all this evidence. Indicts him. On September 25th, a grand jury, 5 days before his statute of limitations expires, if I'm not mistaken, on the September 30th date, a grand jury sitting in the Eastern District of Virginia comes back in. They're like, oh, yeah, he's guilty. Eric, moron. They come back, 2-count indictment. They charge him with making false statements and obstructing Congress, which is like the bare minimum of what James Comey has done. And this is, by the way, these are not the actual crimes that Comey committed. These are Comey lying to Congress about the crimes that he committed. That's how far removed we are from any actual justice. We're like flailing around over lies that this guy said, not even the actual crimes. And the case just got dismissed. All right. But the charges stem from testimony that he gave in 2020. 5 years coming and going. Halligan was the only prosecutor who participated, and only her signature appeared on the indictment. So the judge says, all right. On October 20th, Mr. Comey moved to dismiss the indictment on the grounds that her appointment was unlawful, Section 546. On October 21, the chief judge of the Fourth Circuit designated me, so the Obama judge goes and finds a Clinton senior citizen judge, to consider this and any other motion about the disqualification, about Lindsay Halligan. And continuing, says, finding it necessary to determine the extent of the grand jury proceedings, I asked for all of the information from the transcripts. I got them all. Upon reviewing the transcripts, I determined it did not include any remarks made by Halligan before and after the testimony of the sole witness. So I directed the government to give us more info. Then they submitted a notice. They said, we've already given you everything, Judge. The government provided the transcript. The court's subsequent demand asked for more. We contacted the transcription service and they transcribed everything. So you already got everything. Quit your crying. On November 3rd, the government responded in opposition to the motion. Also, they submitted another order. Okay, so Pam Bondi came in. She issued an October 31st order. But remember, statute of limitations already expired. But put a pause on this because we're going to have a remedy that I think will be coming soon. The October 31 order reads in part the following. So now we know Halligan has been appointed. She appointed her as interim under Section 546. Pam Bondi says, on September 22nd, I exercised authority vested by the Attorney General's office. Under U.S. Code, I designated Halligan as the attorney. Interim attorney over there. For the avoidance of doubt as to the validity of that appointment, and by virtue of the authority as the Attorney General, including these other provisions, 509, 510, and 515, I also appoint Lindsay to be a special attorney. Okay, so it's a separate, we can use this as a term of art, special attorney, using different provisions. In this case, really Section 515. And thereby ratify her employment as an attorney of the DOJ from that date going forward. Now, as special attorney, she can do a bunch of things, because if you go to Section 515, it says you can do all this stuff. Civil, criminal, grand jury proceedings, all these other things. And now she's also that. So I hired her for this role, and now she's also this role. So I delegate also authority to prosecute James Comey via Pam Bondi. So she's trying to kind of, backdate her appointment. Now, in addition, based on my review, I also exercise authority here to ratify Halligan's actions after the fact. Now, Comey responded after Pam Bondi submitted that. On November 13th, judge says, I heard oral arguments from the parties. I took the matter under advisement. And during the hearing, I asked about Halligan and her presentation to the grand jury and said, I'm still missing materials. I also note that based on my review, there's a gap in the grand jury transcript from 428 to 647 when the indictment was returned to the judge, saying, I feel like I'm missing things. Now, the day after the hearing on November 14th, the government filed an unsworn declaration from Halligan and a new order from Pam Bondi. Halligan said the grand jury transcript accurately reflects everything that was said. There's no additional materials to give to you, Judge. You've got everything. That's the end of it. Now, the judge comes down and she writes, resolving Mr. Comey's motion, I need to decide whether Halligan was appropriately appointed under Section 546. This is the 120-day statute. If the answer is yes, I don't need to go any further. If she's valid, then Comey must be denied. But if the answer is no, and Lindsay is not valid, then there was no ability to present the indictment. And if you can't present the indictment, what is the appropriate remedy? Should it be dismissed? Or should it be ratified pursuant to Pam Bondi? I address these issues and start with Section 546, the 120-day provision. Now, according to the government, this case is simple. We read the statute moments ago. In its view, there's only one way to read this. Nothing in the text, it says, explicitly or implicitly precludes the AG from making multiple appointments. In other words, 120 days comes and goes. Okay, appoint him again. 120 days comes and goes. Appoint him again. Or appoint different people. In this case, they appointed Eric Siebert. Okay, he's gone. You get another 120-day appointment. Do you know why? Because the executive branch has the appointment power. And the statute says may. Not that there's a divestment of that jurisdiction and that authority from the executive to the judiciary. It just says may. If it is empty, then you can fill it. So it concludes that the Senate has not refused to advise and consent against Halligan. And so she's lawfully appointed. Now, Comey says, no, you only get one 120-day period. And now they've already used that. She says, I agree with Comey. We'll see what the courts of appeals say. The preeminent canon of interpretation is to presume the legislature means what it says. Now, she says this is ambiguous, this section, which we just read it. It's not. Section A authorizes the attorney general to appoint an attorney. Got it. But there are time limits on appointments made by the AG. It says 120 days. And this gives us one option. It says the district court may, and here's what she says, if an appointment expires under C2, the district court for such a district and only the district court may appoint a U.S. attorney to serve until the vacancy is filled. As an or. It's as an either or. It's not saying that you suddenly take over all Article 2 powers to make appointments because 120 days expires. And we've had prior instances of successive 120-day appointments. We already saw this in the response to James Comey in the underlying argument in the briefing. She says the text and the structure, we're going to come back on this. There's a silver lining to all of this once we get through it. But the text and the structure of subsection D make this clear. The appointment power shifts. The DOJ has 120 days and then they're done. It does not go back to the AG unless you get a Senate confirmed U.S. attorney. The first word in the subsection, if, introduces a conditional clause that establishes the condition triggering the district court's authority. You can read it. Thus, if here it's may, they say the district court retains the authority, and so it's not yours. Now, this reading is reinforced by other documents in Johnson and White, 11th Circuit case, and other things. But if the government's read is adopted, then it would mean that it renders insignificant the court's powers under the statute. It also conflicts with statutory history. Lots of case analysis here, and going back through some of the history here. But the government says, no, Congress came back and actually ratified the long-standing use of 120-day successive appointments. They've done this before. Congress made some changes and reverted it back, so we can do 120 days. Judge quoting a bunch of things. We always like to fast forward through their paragraphs of quotes. Senator Feinstein, who's now dead, talked about this. But in sum, the judge explains, the text, the structure, and the history are pointing one direction. The Attorney General, Pam Bondi, the executive branch, you get a total of 120 days. That's it. If the position remains vacant at the end of 120 days, the exclusive authority to make those shifts to the district court, where it remains until you get a president's nominee confirmed by the Senate. I just can't imagine the courts allow that to stand. Based on that one statute, they're going to divest the executive branch of all of its appointment powers. You get 120 days, use it or lose it, bucko, or else. And some congressional statute that is not a constitutional amendment is going to divest the executive branch of this. We've covered so many cases here that have been reversed on appeal. And, it's always darkest before the dawn, as they say. And you go, okay, they got dismissed, but come on. That's going to be your argument, that the courts are now acting as a fill-in for the executive branch because of some constitutional, not even constitutional, but because of some congressional statute? No way. Halligan was not appointed in a manner consistent with this framework. The clock already expired on May 21. And so since it expired, Halligan is gone. So I conclude that the attempt to install Halligan was invalid and that she's been unlawfully serving in that role. And now I am the president. I am the executive branch. The court gets to make the appointments now moving forward. Now, she says it violated the appointments clause, which is hilarious because the court is now saying we run the appointments clause. It's our Article 2 now, not yours. They say the appointments clause allows Congress by law to vest appointment in inferior officers. In the president, right? Constitution, Article 2, Section 2, Clause 2. What does this say? She wrote it right here. The appointment of inferior officers and officers are vested in, what does that say right there? Oh, yeah, the president alone. Not some committee of judges somewhere. They get to say, actually, we don't like Lindsay, so we're going to appoint somebody else over. The Constitution says the president alone. And the court, in this decision, is operating against that, which is why I think this will be reversed. Through Section 546, Congress has devised a scheme that vests this in Congress. And because Halligan was appointed in violation of this scheme, everything that comes from her is bad. Resisting this conclusion, the government says, well, not every action in excess is a violation of the Constitution. Lots of quotes there. But what is the remedy? Dismissal. Says this is more than just a matter of etiquette or protocol. Here, Comey says Halligan was unlawfully appointed, and therefore all of this was void ab initio. And I agree. So everything is invalid. He therefore argues the case must be dismissed because Halligan was not lawfully exercising executive power when she appeared before the grand jury alone. She agrees, the judge says. And so now the case needs to be dismissed. Now, I conclude that all actions flowing from Halligan's defective appointment, including this indictment, must be set aside. There is no alternative course, and so I have to dismiss the case. The government says that's ridiculous. It's been validated, this entire process, by the U.S. Attorney General, and they say she was still a valid attorney. Even if she wasn't a valid U.S. attorney, she still brought this indictment appropriately, and they rely on the 1031 order. But the judge is going to say, sorry, you can't do that. This is not a mere paperwork error. Okay, when she got originally appointed, Pam Bondi put her in here Section 546. And by the way, like, it's easy to come and blame Pam on that, I think, to say, well, you would have been smarter if you wouldn't have done this because this gave them an opening to say that her successive appointment was invalid and dismiss all of the indictments. But what they were trying to do is make her the U.S. attorney, right? And this is going to be an important battle to wage anyways. Not just as it relates to these prosecutions and Lindsay Halligan, but we want to make sure that the executive branch can actually appoint their U.S. attorneys. So they use this statute. Maybe it's the weaker of the statutes because it enabled this attack, which was to say 120 days is time limited. But you also want the DOJ to push that envelope to say, no, we can appoint our attorneys. We're the executive branch. We get to appoint our people. We don't divest ourselves of that power because some court somewhere say so. So we're going to have this battle. You know, it kind of sucks that we're having it with Comey. We got to have Comey and Letitia dismissed, but we're going to have this battle one way or the other. So it's hard to really blame them for using this statute. They then created a backstop when they're like, oh crap, they're going to dismiss on this basis. They then came out and tried to use the 1031 order with different statutes, 515 predominantly. She says, well, sorry, you're not a special attorney. But my point in going through this in so much detail is that this status, somebody else, I think, could be appointed as a special attorney now that the case has been dismissed, which creates the safe harbor window of the 6-month statute of limitations kind of, safe harbor provision that would allow a new special attorney, if we're not appealing it, or maybe you prosecute these things simultaneously, but you actually would appoint a new special attorney. And we'll come back to that. But regardless of what the attorney general intended or could have done, the fact remains she wasn't authorized to even conduct these when she got the indictment. And now it has to be dismissed. Now, the government also says that even if Halligan lacked the authority, we're entitled to de facto validity. But this doctrine applies only to some non-constitutional appointment challenges. This is a constitutional appointed position. And so that analysis doesn't apply. But third, the government also says, well, the grand jury came to their own independent decision, and so it's harmless error. But they say harmless error doesn't apply here anyways, because she didn't even have the power to go in and present the evidence to the grand jury at all. Now, the government finally argues that even if Comey's indictment is flawed, dismissal is inappropriate because the AG ratified this. But all of it happened after the statute of limitations. I've already concluded, writes the judge, that Halligan's original appointment was invalid, and you can't retroactively fix it, saying the AG could not have authorized Halligan, who was not an attorney for the government at the time, to present the indictment, right? There's essentially saying the very moment that she was appointed, that was illegal because only the courts can come in and actually appoint somebody to that seat. Now, the implications are extraordinary. It would mean the government could send any private citizen off the street, attorney or not, into the grand jury room as long as the AG approves it after the fact, and that's not the law. So the government is not satisfying this ratification. Pam Bondi can't revert back. And here's an interesting footnote. Generally, the return of an indictment tolls the statute of limitations on the charges contained in the indictment. In other words, the clock stops. You've got, in this case, a 5-year window to prosecute James Comey. Charges are filed. Clock stops on the window. Here, though, this indictment was invalid, so the clock did not stop. A valid indictment insulates the statute of limitations, but if the indictment is void, there's no peg on which to hang this tolling result. Okay, so in other words, the statute of limitations has also expired. Now, there's another statute that I think saves us on that, but we'll come back to that. Saying here, now on October 31, Comey's indictment was still pending, and so the clock expired already. Thus, the AG could not have invoked 3288 at the time the ratification was made. And what is 3288? Our friend Will Chamberlain pulled this up for us. And he said, this is an important note here, okay? When you have a dismissal of an indictment, shout out to Will for digging this up. Also, an important white pill, he says, because the original indictment was timely filed against Comey, DOJ has a 6-month period to re-indict, even though the statute of limitations would have run by now, had Comey never been indicted. And here's the statute. It says 3288. Okay, whenever an indictment charging a felony is dismissed after the statute of limitations has expired, a new indictment may be returned in the appropriate jurisdiction within 6 calendar months of the date of the dismissal of the indictment, and more. If no regular grand jury is in session, then you've got a couple of exceptions to that, but this section does not permit the filing of a new indictment if the reason for missing the statute of limitations, like if you miss the window, you're like, oh, I just forgot to file it, you can't refile it if you failed to meet the statutes the first time. So you might call this like a safe harbor provision, to use a contract term, or an opportunity for prosecutors to cure a bad indictment and refile the charges. And so let's put a pin in that, right? The judge is saying, hang on, you can't use that in certain circumstances. And here's what the judge said. Okay, 3288, the Attorney General could not have invoked this at the time the ratification was made. In other words, Pam Bondi on October 31st couldn't have approved Halligan's decisions because it was an active indictment. So she can't reappoint Halligan because it's an open case. But guess what is now the situation? The case is dismissed. So now we can use 3288 because the case was still open back then. It's invalid. The case is now dismissed. So now we can use that, which means you could say that they could use Section 515 to appoint a special attorney, probably not appoint Halligan, but you'd appoint somebody else. And then they could use 3288 to invoke the 6-month window and bring a new indictment, all while simultaneously appealing the case. So there's 2 options there that I think are pretty good. It says, having found that Halligan's appointment violated 546, which is the 120-day consecutive law, and that the dismissal is warranted, we now should ask whether it's with prejudice or without prejudice. And as we know, it has been without prejudice. It says, I believe the appointments clause jurisprudence begs the question, and I will invalidate these and I'll just dismiss the indictment without prejudice, returning Comey to the status he occupied before being indicted. And so therefore, judge finding that U.S. attorney violated section 546 because she was appointed 120 after 120. And I think the courts will probably reverse that. It seems ridiculous, just as a matter of public policy, without getting into all the case law, that the courts, because of an empty seat, get to usurp executive power. I think may in there is for a reason. It's may. It's not yours. You can, help yourself to the refrigerator if you want and, open the door, but it's not yours. It's the executive branch. And so for this judge to take it away from the executive, I don't think the Supreme Court's going to sit by that. All actions flowing are set aside, and any AG attempts to ratify Halligan are also set aside. Motion to dismiss granted, indictment dismissed without prejudice. And she says, this is her main ruling, which I think is probably going to get reversed. The power to appoint an interim attorney during the current vacancy lies with the district court until we get a Senate confirmed attorney. Okay, so in other words, in this district, until we get a Fourth Circuit reversal or a Supreme Court stay or a reversal or any of these, limitations on this Clinton judge, the court will appoint the next U.S. attorney. So the idea is nobody else is going to be filling that seat. A special attorney, I would argue, would be outside of a U.S. attorney. So if she uses Section 515 to go and appoint a special attorney, Pam Bondi's already tried to do this. She already tried to do that with Lindsay. So just go do that again for somebody else who is going to investigate and prosecute these cases. Also appeal this one because we want Lindsay Halligan in the U.S. attorney's seat, and we want the executive branch to have the power of appointments, just like the Constitution says. So this judge, I think, is just way off base, and I think that she'll probably get reversed on both cases. But this is also the Letitia case, and again, saying nobody else can come in. So they can't put in another interim attorney. It's got to be Senate confirmed, presidential appointed, Senate confirmed before they'll accept them. And the Democrats are not going to agree to appoint anybody who wants Comey prosecuted. If Comey gets tabled, then we'll push through these senators, the Senate, a new U.S. attorney. But you can see how politically this is going to be a difficult thing. So two options. One, appoint a special attorney under Section 515. Two, appeal this, get Lindsay Halligan reinstated, and have the courts find that successive appointments are perfectly valid under Article 2 powers. So difficult decisions that came down, but ultimately I think that they're just as bad as anything we've seen from these other judges who've all been reversed. So it is going to continue to be a battle, and I think that the Comey folks are celebrating a little bit too early. They're popping that champagne bottle, which they shouldn't be doing quite yet. Chad Mizell, no longer with the DOJ, but he was with the DOJ. He said wrong, just until very recently, wrong for many reasons, he says, including that dismissal of these indictments is the wrong remedy. Okay, even if you think Lindsay Halligan was illegally appointed or something, you still had a valid indictment from an attorney who was working for the U.S. government, even if the title was wrong. And so the idea would be they're going to dismiss a criminal charge, two felony criminal charges, in this case multiple, against Letitia and Comey, that a grand jury duly approved just because of some technicality. We'll see. Both indictments were ratified by senior DOJ leadership, including the AG. This may delay justice, says Chad, but it won't stop it. An appeal is coming. Comey and James are not off the hook. Caitlin Collins said Letitia was very happy about this. After her face stopped spasming out, she said, "I'm heartened by today's victory, Letitia, and grateful for the prayers and support I've received. I remain fearless in the face of these baseless charges as I continue fighting for New Yorkers every single day." But Harmeet came out and said, without prejudice means we can file this next time and come back with a second set of charges and a new indictment with a valid a U.S. attorney. Let's see if the DOJ has commented on this. I've been waiting to hear from Pam Bondi and the DOJ to say, what are we doing? Are we appealing this, everybody, or what's going on? Okay. Memphis Task Force later today. White collar executive incarcerated. Not good. We don't want those criminals out there. Okay, so nothing from the DOJ on the dismissal of these charges. Here's over from Pam Bondi's account. See if they've posted anything 3 hours ago, which is plenty of time to come up with an idea. She says, we're going after Hawaii in the Supreme Court over gun laws, and we're suing Gavin Newsom. Okay, so no comments on Comey from them. Comey has had time to make a video here. Nothing from the DOJ, but Comey got a video up. Here's a little bit of this. I'll just play a small sample so you don't yak your guts up.
I'm grateful that the court
voice way too loud, face way too close. Here he is.
Ended the case against me, which was a prosecution based on malevolence and incompetence, and a reflection of what the Department of Justice has become under
your whole existence is malevolent.
Donald Trump, which is heartbreaking. But I was also inspired by the example of the career people who refused to be part of this travesty. It cost some of them their jobs, which is painful, but it preserved their integrity, which is beyond price. And I know they will serve again. I was very lucky that some of the best lawyers in America stepped forward to represent me.
Yeah, Patrick Fitzgerald was one of your lawyers, the same guy who you were emailing. Back when we're saying you committed these crimes, and we're making those allegations. So it's very convenient how your lawyers came out, and then suddenly you invoked attorney-client privilege to try to hide evidence from the attorneys who, in our opinion, were co-conspirators in your crimes.
I hope they serve as an example to more and more lawyers, especially at some of the big firms, to participate in protecting our liberty, protecting the rule of law.
Yeah, the Democrats have seized the judiciary, the courts, the law schools, and most of the law firms, all in alignment with their sick ideology.
And my family and friends were always with me, and luckily for me, include some of those great lawyers.
Maureen?
This case mattered to me personally, obviously, but it matters most because a message has to be sent that the President of the United States...
Okay, so dramatic. Now, he, of course, is hopefully going to be indicted again once they sort out some of these technical things, because we saw the evidence come out. He had emails to Daniel Richman. He had his handwritten notes saying that he knew Hillary Clinton was trying to tie the Russians to Trump and to attack him. There were burn bags. He had a fake pseudonym email, Reinhold Niebuhr, as he's Gmailing classified information to his lawyers from the White House, from the FBI building. So that's James Comey. Hopefully he's indicted again. Let's see what Kash Patel's up to over there. Oh, here's Kash. Man, he looks good. Look at that nice little jacket. He says, the FBI is proud to partner with Homeland. We're going to go and secure these sporting facilities. Club World Cup, FIFA, Summer Olympics, Grand Prix. Man, he's going to do a lot of work securing all those events. Probably the day of the events, huh? And more to ensure top security infrastructure standards, keeping Americans safe. Great visit to our teams. All right, let's see how Kash is doing. Man, he's looking good over there. Yeah, nice outfit, tailored up and everything, looking good. Security, taking some more photographs. Man, FBI director. Wow. That looks like a command center over there. Yeah, wow, on the road. Wow, amazing. They look so happy and they're having so much fun. Meanwhile, corrupt FBI directors are getting their charges dismissed in America. Isn't that fun? Anyways, here's Caroline Leavitt. She came out. Did Kash post anything today? That was from last night. Let's see if there's anything today. Great work at FBI Atlanta. Yeah, we're arresting drug dealers. Great. Yeah, that's great. No, we don't. That's a lot of drugs. That's a nice bust. Who got this one taken care of? Oh, the sheriff. Oh, the sheriff's got it done. Yeah. Sheriff Hall County, Office of the Sheriff. Man, shout out to the Georgia sheriffs out there for doing amazing work and then having the FBI take credit for it. FBI Atlanta and local partners. It's the Hall County sheriff's Kash. That's great. That's great. And again, we don't want drugs on our streets at all. But that's just like basic low-hanging fruit. And stop taking credit for local cops, all right? You have an FBI director who tried to steal elections from the whole friggin' country, okay? And is now getting away with it. and he's posting photos at sports events. Oh my gosh. All right. So that's cash. Here is what Caroline Leavitt had to say about this today.
I'm grateful that the court ended the case against me, which was a prosecution based on malevolence and incompetence, and a reflection of what the Department of Justice has become under Donald Trump, which is heartbreaking.
What's White House response to that, and what can we expect will happen next, Caroline?
Well, what I will say is that everybody knows that James Comey lied to Congress. It's
That's
as clear as day. And this judge took an unprecedented action to throw these cases out to shield James Comey and Letitia James from accountability based on a technical ruling. And the administration disagrees with that technical ruling. We believe the attorney in this case, Lindsay Halligan, is not only extremely qualified for this position, but she was in fact legally appointed. And I know the Department of Justice will be appealing this in very short order. So maybe James Comey should pump the brakes on his victory lap.
Yeah, James, put that champagne bottle down. Letish, cancel your cruises with Big Fanny. It's not over yet. We'll be appealing this, we believe. Now, here's more from Caroline. She was out talking to the press outside the White House.
No, because Lindsay Halligan was legally appointed, and that's the administration's position. I know there was a judge who is clearly trying to shield Letitia James and James Comey from receiving accountability, and that's why they took this unprecedented action to throw away the indictments against these two individuals. But the Department of Justice will be appealing very soon, and it is our position that Lindsay Halligan is extremely qualified for this position, but more importantly, was legally appointed to it.
Yeah. All right. So that was that one. And she got a couple of questions about this. Here was another funny little exchange where this woman really wanted an answer to her question.
As possible.
Is the president more determined to go after Tish James and James Comey?
Go ahead.
Is the president more determined to go after Tish James and James Comey?
Excuse me. I'm answering a question from
You
your...
and looked at me. I'm sorry.
I turned and looked at you because you're yelling. I will
That's
take a
right.
question
That's what
from
we
your
do as
colleague,
reporters.
and then I'll take your question
Thank
too.
you.
Okay? Go ahead.
So, yeah, hopefully the investigations continue. And we've seen, again, a lot of bad decisions come down that are reversed basically immediately. For example, we just had the Texas order from psycho Judge Brown out there who said that the maps were racist and he had to revert those back to the 21 maps. And then Alito came back down and put a stay on it. So we'll have our battle ahead. We were always expecting some difficulties with these judges because they're just spring loaded. They're looking for any justification to protect their institutions. In this case, a Clinton judge coming in to protect Comey, who was trying to rig the election in favor of Clinton. Isn't that fun? So we've got a lot more to cover on this. I'm expecting to see appeals come in any minute. And once we get the full memos, we'll go through them right here. Thank you for subscribing and joining as we do. All right. So those were not the greatest of headlines, but I think that they'll come back. I think that they'll come back. So it's a temporary setback, but now we do have some more fun stuff to get into, including this one. Bill and Hillary Clinton are now on notice. They better show up for their deposition or else. James Comer sent them this letter as a follow-up to their subpoena that they got a long time ago. And remember what happens if you ignore a congressional subpoena, according to the Democrats? You go straight to jail. That's what happened to Steve Bannon and Peter Navarro when they didn't show up after the illegally constituted J6 committee tried to drag their booties in there. But now Comer is saying, all right, Bill and Hillary, no one is above the law. And now you better get in here, saying, all right, look, you know, Democrats and Republicans approved subpoenas in July for Bill and Hillary Clinton and many others. After good faith efforts to schedule depositions with them, further delays aren't acceptable. Given their Epstein ties, avoiding Congress would be in defiance of subpoenas, and they would warrant contempt proceedings. But then there'd have to be a criminal referral. It'd have to go over to Pam Bondi, and she'd have to do something about it. So don't get your hopes up. But here's what Comer said. Today, House Committee and Oversight Government Reform Chair Comer sent a letter to Hillary Clinton's lawyer saying, hey, we're engaged in good faith negotiations, but you better show up here or you're going to be in big trouble, Bill and Hillary. Here's what the letter says. All right, Mr. David Kendall, senior counsel at Williams and Conley. All right, lawyer for Hillary. The committee has received your letter that you sent back to us outlining your arguments why you say Bill and Hillary should not be required to appear. You call it for live testimony. Now, the crux of your argument is that the committee should accept, quote, a written proffer of what little information the Clintons may have, because you think it's going to be the most efficient and equitable way to proceed. You want to just send us a love note? Now, the committee disagrees with you, David. You highlight the fact that the committee elected to forego deposing other individuals subpoenaed. And I think, like, who else was supposed to come? Somebody I think was brain dead, like Mueller, maybe. Anyway, he's like slobbering all over himself, so that they didn't require him to come in. However, your assertion conveniently ignores the fact that individuals affirmed that they lacked any information or otherwise that they lacked any information or have serious health issues like others have. Okay. Other people lacked any information and the others had health issues. So we let them go. But as your letter indicates here, David, lawyer for Bill and Hillary, they do possess information that we want. You even said in your letter, what we have learned over the years about Jeffrey and Ghislaine is abhorrent. The public's demand for transparency from its government about their criminality is both understandable and warranted. So their lawyers are even like, yeah, it's important. Former President Clinton and Hillary welcome legitimate oversight if it's grounded in fact. And in that regard, their lawyers write, former Bill Clinton and Hillary have little to contribute to that goal, but you do have something, don't you? Thank you for that. All of which can be readily submitted on paper. So given the admission that you just made that they do have a little, it amounts to a demand that the committee forego in-person testimony for relevant info. Like you just said, you've got a little info, but now you don't want to show up to tell us about it? Why are you trying to obstruct us? The committee sets the terms of its oversight, okay, not you, including deciding which witnesses to interview, in what order to interview them, and whether or not to compel testimony in a time, place, and manner of our choosing. Federal courts have also consistently held that you don't get to impose your own conditions on us. That's because a witness does not have the legal right to dictate conditions under which they're going to testify to us. So simply put, David, the fact that other witnesses may have been afforded certain accommodations is not a defense to a congressional subpoena. They're slobbering all over themselves. That's why they didn't come in. Now, the committee is not obligated to defer to either you or your client's determination that the importance or quantity of information is irrelevant. We decline to do that. Rather, our committee is entitled to a fulsome examination of this information, which should include the ability to elicit the information in person and to ask relevant follow-up questions of Bill. While you argue that the committee has not provided a persuasive rationale for deposing the Clintons, you say it needs to be a required bit of evidence, but that's not the standard. The committee need only conclude that it would be helpful. They don't need to have information that is required for our information. It's only if it's helpful too. Then we can ask. Therefore, the committee does not find your argument against this compelling at all. So they're coming in here in person. Now, additionally, David, your suggestion that your clients, Bill and Hillary, would not be relevant, their testimony, to the purposes of our investigation because it's outside of their official duties misses the point. It is precisely the fact that Bill and Hillary each maintained relationships with Epstein and Maxwell in their personal capacities as private citizens that is of interest to us. We're not even asking about their official duties. It's all about their private flights. And so in sum, David, lawyer, your arguments lack merit and completely ignore the lengthy rationales that we already told you about. And so accordingly, pursuant to our subpoenas that we sent back in August, these new depositions are scheduled for the following dates. Bill Clinton, get in here, December 17th at 10 a.m. in Washington, D.C. And Secretary Clinton, hang out close by, December 18th, 10 a.m. Just get a hotel together and just come in one day after another. We have authority to investigate these things, and that's what we're doing. Sincerely, your friend, James Comer, Congress. And we'll see what they say back. But that's coming up soon. We just got a couple of weeks until we can expect them to be there. December 17th, December 18th. They better be there. And if not, these Republicans, man, they better start these contempt proceedings instantly and refer those over to the DOJ. And then Pam Bondi and the rest of them can figure out what to do about that, which means they better impanel grand juries and indict them, just like they did with Steve Bannon and Peter Navarro. And they can share a cell together when they serve out their 4 months. So that came down. We also see that in the Epstein matter, the DOJ has now submitted a no and another motion to unseal the grand jury transcripts. Woo. We already saw this happen once before. We read through both of them. One in New York, one in Florida, the last time we tried to get these unsealed. But something has changed now. Congress has, of course, passed the law. So now they can say, well, not only do we want it as the executive branch, but the legislative branch has also said, release their files, please. So here is what they've submitted, not a long filing. This one's in the Southern District of New York in the grand jury matter that's related to the Epstein case. Says, all right, listen, Judge. At the direction of Pam Bondi, the DOJ files this motion to ask the court to unseal the files. The DOJ previously petitioned this court to unseal these records before. Back in July, we read it. The court denied that petition, saying, well, the rules don't approve any of this. Now, after the court entered its order, and we read it, we read through their motion. They're just like a sticky note, like, will you please unseal it? They're like, what? No. I'm like, okay, fine. Anyways, after the court entered its order, Congress near unanimously passed and the president signed the Epstein Files Transparency Act. There are certain exceptions, but it does say that Pam Bondi, no later than 30 days, needs to make all of this stuff available. It requires the DOJ to publish the grand jury transcripts associated with these investigations unless there's a basis for withholding them. And so accordingly, subject to appropriate redactions allowed by the act, the DOJ once again moves the court to unseal the transcripts so that we can see them. In support of this request, we also state the following. Now, based on what we know about these grand jury proceedings, I think that there's probably very little in there that is substantive. We know that the Maureen Comey was leading both of these, and that the indictments and the grand jury proceedings were very short in time, like one witness and PowerPoint slides, like 30, 90 minutes tops. So there's not going to be a huge trove of information that leads to other people being indicted. Now, let's see what they've got for us here, because there was the 2007 grand jury. On July 2019, a grand jury returned an indictment in the Southern District of New York. There was a protective order saying none of this stuff could be posted. Then Epstein committed suicide in his cell. Official DOJ position. Okay. On June 29th, the grand jury then, 2020, indicted Maxwell. Okay, these are both the new cases. 2019, this is a cleanup operation. 2020, Maxwell, cleanup operation. The real crimes were covered up back in 2007. The court entered a protective order saying, don't post anything about this. Jury came back, found Maxwell guilty. Nobody else was even hardly discussed at the trial. No other predators. In light of the public interest in this, we asked you to unseal. You denied the request to unseal. You also denied it in New York. Now, on November 19th, the president, Trump, signed into law the new Epstein Files Transparency Act, saying you got 30 days, release the files. They must release things, including all investigations, prosecutions of Jeffrey, Ghislaine Maxwell, flight logs, itineraries, pilot logs, vessels, vehicles, all the things, all individuals, entities, any immunity deals, internal DOJ comms. Man, that's going to be good stuff right there. But again, for what date range? Yeah, what date range? Says the act allows for certain withholdings for victims, victim information, or anything that would jeopardize a federal investigation, and also classified information, which is weird. how you have classified information in just a criminal case involving just a regular standard predator. Finally, the act also requires Pam to submit a report listing what has been withheld and what is not being released. They say, we know the rules in a grand jury are to normally keep this stuff secret, but the act has given us a clear mandate. And you too, Judge. The court should authorize the Department of Justice to release the transcripts and lift any other protective orders that would permit disclosure because Congress said so. We got 30 days. We need you to go. Let's act quickly on this. And so we got two branches now. The legislative and the executive branches have nearly unanimously directed the DOJ to make these files available. Specific language in the statute from Congress overrides the grand jury secrets and the rules protecting them. And so you should publicly release all of these things, lift any and all pre-existing protective orders, unseal everything from Manolo. What's up, Manolo? Shout out. We'll see what the courts have to say about that, but they've got two branches now. So hopefully those documents are unsealed very quickly and we can peer inside of them. But the Democrats are still reeling from this. It's like the dog chasing the cars who finally caught the car. It's like, what are you going to do with it kind of thing? Raskin, he's now getting called out. We saw Stacey Plaskett was scrutinized, rightfully so, for literally texting with Epstein like a puppet, getting instructions from him while on her congressional seat. And now Raskin is still trying to cover for her. Here is how that conversation went down on CNN.
Ask you about Democratic Congresswoman Stacey Plaskett. Last week, as you know, there was a failed censure effort over her text with Epstein during an oversight hearing in 2019. He was a known sex offender. She acknowledged Epstein's influence in her line of questioning during that hearing on this show when we had her on, but would not say it was an error in judgment. Here's how you defended her on the House floor last week so our viewers can listen.
However ill-advised it may have been, she took a phone call from one of her constituents. They've arraigned a Democratic member for taking a phone call from her constituent, Jeffrey Epstein, in the middle of a hearing. And of course, I don't think there's any rule here against taking phone calls in a hearing.
And to be clear, she initiated the text chain on that day. But are Democrats losing the moral high ground on the Epstein issue by defending her as you have?
Well, look, we've been demanding a complete release of the file, and now they wanted to discipline her, censure her, because she'd engaged in that text exchange with a convicted criminal.
Yeah, she was receiving instructions from a man who was convicted to take out her political opponents, and the Democrats just rolled over. Many Republicans did too, and just said, well, that's okay. If we punish Stacey Plaskett for sending texts to Jeffrey, we might have to punish half of Congress for all we know. So the records are hopefully getting released soon, at least the grand jury portion of it, now that we've got the executive and the legislative branches both saying the courts must do it. And Bill and Hillary better get their act together, man. They got subpoenas that have been served and delivered, and we've got dates queued up for them. Get your butts in here, December 17th and December 18th, or maybe you can spend Christmas in jail. Not that the prosecution will move that fast, but maybe jail 2026. We'll keep our eye on this one, my friends. Thank you for subscribing and joining as we do. All right. And we got one quick update, and then, my friends, we'll hear from you. Seditious senators now in trouble. One in particular called Mark Kelly from Arizona. The Department of War came out today in response to their little video. They're like, don't follow unlawful orders. Do you have any unlawful orders to reference? No. Oh, okay. So you're just trying to undermine military readiness because you hate Trump. Got it. So the Department of War came back down and said, all right, look, listen, this is our official statement here from the Department of War. We have received serious allegations of misconduct against Captain Mark Kelly, retired, U.S. Navy. In accordance with the Uniform Code of Military Justice and other applicable regulations, a thorough review of these allegations has been initiated to determine further actions, which may include recall to active duty for court-martial proceedings or administrative measures. This matter will be handled in compliance with military law, ensuring due process and impartiality. Further official comments will be limited to preserve the integrity of these proceedings. Now, the Department of War reminds all individuals that military retirees remain subject to the UCMJ for applicable offenses, and federal laws like 18 U.S. Code 2387 prohibit actions intended to interfere with the loyalty, morale, or good order and discipline of the armed forces. Any violations will be addressed through appropriate legal channels. All service members are reminded that they have a legal obligation under the UCMJ to obey lawful orders and that orders are presumed to be lawful. A service member's personal philosophy does not justify or excuse the disobedience of an otherwise lawful order. And of course, all those goofs on their little video, they all know that. Hegseth came out and said, the video made by the Seditious Six was despicable, reckless, and false. Encouraging our warriors to ignore the orders of their commanders undermines every aspect of good order and discipline. Their foolish screed sows doubt and confusion, which only puts our warriors in danger. 5 of the 6 individuals in that video do not fall under the Department of War jurisdiction. 1 is CIA, 4 are former military but not retired, so they are no longer subject to the UCMJ. However, Mark Kelly from Arizona, retired Navy commander, is still subject to the UCMJ, and he knows that. As was announced, the department is reviewing his statements and actions, which were addressed directly to all troops while explicitly using his rank and service affiliation, lending the appearance of authority to his words. Mark Kelly's conduct brings discredit upon the armed forces and will be addressed appropriately. And Mark Kelly, he came out in a video and he said, "You think I should die?" Trump essentially said loyalty to the Constitution is punishable by death. I don't think that's what he said at all, actually. I think he's saying that you undermined the Constitution. You're undermining the commander-in-chief's lawful authority. You're encouraging disunity in the military ranks as a former military member, using your label in order to accomplish that goal. That's what he was doing. So you're the one who is undermining the Constitution and the lawful chain of command. Those are dangerous words coming from the president, but I'm not going to be intimidated, says Mark Kelly.
People to understand, Margaret, that the message he sent a couple days ago was he declared that loyalty to the Constitution is now punishable by death. Those are serious words coming from the president of...
Okay, so he's just reading his tweets on cable now. All right, so he also posted this. I swore an oath. We appreciate our service members. Yeah, and I don't think if he was here and some oppositional politician was like lecturing him about following lawful orders or something, that he would appreciate that. But now, since he's not in the military and he hates this commander-in-chief, he's okay being the one to do that. Exactly. So Caroline Leavitt was out today, and here's what she said about this. It sounds like they are looking into it, and the White House stands by.
The White House is supportive of the Department of War's investigation into Senator Mark Kelly. And I think what Senator Mark Kelly was actually trying to do was intimidate the 1.3 million active duty service members who are currently serving in our United States Armed Forces with that video that he and his Democrat colleagues put out. Senator Mark Kelly well knows the rules of the military and the respect that one must have for the chain of command, and that all lawful orders are presumed to be legal by our service members. You can't have a functioning military if there is disorder and chaos within the ranks, and that's what these Democrat members were encouraging. It's very clear, and not a single one of them, since they've been pressed by the media, and I'll give you guys credit for that, can point to a single illegal order that this administration has given down, because it does not exist. They knew what they were doing in this video, and Senator Mark Kelly and all of them should be held accountable for that.
Yeah.
The White House is...
All right, so they're looking into it. We'll ultimately see what comes down, but Trump was also out this morning posting a bunch of reposts on Truth about why these seditious six should be held accountable, but we'll see ultimately what comes down. Looks like it's over at the Department of War, and Mark Kelly and the Democrats responding, freaking out, really, trying to explain their little video. But without any specifics, it is hard to make an argument because they have none. There are no illegal orders, and they should have more respect for the men and women of our military rather than thinking that their little senator video on TikTok is going to usurp the proper chain of command. And now repercussions are coming. We'll keep our eye on this one. Thanks for joining as we do. All right, my friends, what a beautiful and interesting stream it has been today. Would prefer a stream with less criminal dismissals, but here we are. We're going to keep our eye on that. I think that it's going to be coming back, so don't fret too much out there. But thank you so much for being here. Thank you for subscribing to our channel. And thank you for sending these donos in. Man, you guys are awesome. Very nice of you to do this. And what the heck do we have going on here? We got some technical devices happening. Hey, it's Monday. Have a great day. It's Winnie the Pooh. What a friendly little bear he is, isn't he? One old guy says, you know, colonial Islam doesn't care because when they take control of the CIA, when they become the majority in the long run, will Epstein be that big a deal? Are the Islamists taking over the CIA? I thought it was the communists, really, but yeah, that's also a concern. Here's this guy. There are some who call me Tim. Tim Jake, what's up? Tim, hey, one of two. Last week, an 11th Circuit panel found 3-0. There is no COVID exception to the takings clause. Oh, I think I saw that headline. Yeah, in 5A, landowners sued Walton, Florida for prohibiting the use of their own property. Yeah. So, like 5 years later, we get a ruling. You can't tell people they can't go outside. Case number is 21-13999. The owner shall be compensated. Yeah, man. We haven't even started with any COVID accountability yet. At all. Tim Jake, what's up? Thank you for those donos, man. And that might be a good one to go through. Is somebody appealing that? 11th Circuit, COVID rules. I know Rand Paul's been doing a lot of the COVID stuff and follow up there. We haven't even gotten into COVID. So mad about J6, Butler, Charlie Kirk, Tish, Comey, all of the coups. We haven't even started with COVID. Tim, thank you for that. Jeffrey Adams. Hey, sorry this morning's message was so cryptic. Well, that's okay. We like a mystery every now and then. Your show is at my gym time and I was on the treadmill. Yeah, it's hard to type on a treadmill, man, especially if you're going at like 6 or 7 speed. Trump should remove their security clearance. I think we got that. I think we parsed that together from your texting. Yeah, Trump should remove their security clearance from the senators, maybe, is what we were talking about. Jeffrey, hopefully you had a great workout. Hey, what's going on? Hey, Rob. With sad news, my pup has the C word. If it's okay, I share my GoFundMe in your X comment section. Yeah, of course, share it over there. And then if you're following us over on X, you can see it. The kingly pampering has cranked 100%. Shout out to your boy. We don't like the C word, man. It's tough. Hopefully, you can find some funds over there, Catherine, to help your boy. But sure, yeah, feel free to post your GoFundMe over on X, and we'll highlight it right here. Chubby says, seriously, when is this blatant judicial coup garbage going to be enough for SCOTUS to step up and do their dang jobs? All they're doing right now is displaying for the world what a joke our justice system currently is. Why do we even have laws anymore? Sorry, just getting frustrated with all this. Man, I hear you, Chubby. And Chubby's a lot less chubby. He's kind of not so chubby stubby now. We saw some progress photos this morning. Looking good, Chubby. But yeah, I agree with you. We finished the morning stream and I got off and I was like, oh, wow, both cases have been dismissed now. That's incredible. Like, what the hell is going on, man? But this is part of the battle. We're filled with corrupt people. So it is frustrating. But I wouldn't count on the Supreme Court to do anything. I wouldn't really count on Congress to do anything because they're all a part of the same system and they're all just waiting for Trump to go away so they can get back to what they're doing. The ban Hagel, Robert Gouveia for Attorney General. Man, I would go in there. I'm not really qualified for the job, but it would be just a bloodbath. And I'd probably go to prison afterwards. The Democrats would take over, end up in the gulags. I mean, not like violent, but it would be like, everybody would be fired immediately. Huge chunks of people. I'm like, You're letting all the drug dealers go. That's deal with it. Local cops, local prosecutors, you guys got to deal with it for now. The DOJ and the FBI, they have to go away. So everybody's just getting fired. And it would be just a glorious day. Could you imagine what a beautiful... I wouldn't be on the job long, that's for sure. Because once you fire the entire department, it's pretty much over. Glenn Croy, what's up? Chubby Chick, welcome. J.R. Williams, Snowbird is here. Karina Andrews, what's up? Gracie B. Julie. Yeah, it'd be worth it, man. And you go down as a hero. Spend the rest of your life in a gulag somewhere, but at least, like, man, you went out. It's like that meme, like that Leroy Jenkins meme. Aren't they in the World of Warcraft? And he's like, this is it. We just have to go in. Everyone's like, no, wait, we have to. Leroy Jenkins. And he goes in. It's just a total, that's basically how I feel. Sharpie guy, 2 questions, Rob. Do you think Bondi is cooking up the conspiracy charges, or is she completely incompetent? And don't you wish Matt Gaetz got AG? I do. I think Matt Gaetz would have played. Like, he would have come to play for keeps. What we're playing right now is like, coloring books. It's just like such a joke. And the Democrats are going to come in. And all of these Pam and Cash and Dan and all the, like, you think they're going to be immunized from this revenge? They're not. Ken loves Murica. Can't have it both ways. Jack Smith case got dismissed because he wasn't a properly appointed POTUS. Yeah, but Jack Smith was appointed as a special counsel under the Reno regs. So it was a different statute. Bondi could have appointed Deputy AG Blanche under 515A. Yeah, so 515A is the special attorney. I think Bondi could have appointed Lindsay Halligan under 515. I don't think you need to be a duly appointed U.S. attorney. I think under 515, you can just be a special attorney. I don't think you have to be U.S. confirmed. So she could have done that for Halligan, but I think that she didn't because she wanted her to be the interim attorney. And the special attorneys it's much more limited in jurisdiction. So they wanted to go all the way with Halligan to make her the interim attorney and want that to stick. And as I said in that segment, we're going to have to fight over this power anyways, right? Just like we're fighting over the tariff power. Can the president do that? Yes or no? Can the president appoint 120-day successive interim attorneys? Does he have that power? Yes or no? So we're going to have to fight this out anyways. And I think Halligan is a brave woman. Okay, she's Leroy Jenkins-ing that thing hard. She walked right in 5 days later, indictment. There's courage to that. It's a very brave thing to do. She had to go against all of the institutionalists. So I'm not mad at her. And I even think Pam was trying to shoehorn her in, and this issue was going to come up. It sucks this issue's coming up with Comey and Letitia, but we gotta have the battle out. So, yeah, I think Jack Smith, if you look at Jack Smith's appointment order, he was, I don't even know if they called him a 515A. I have to look that up again. But it was the Reno regs. So it was even less specific than these. Maybe 515A was used for him. I don't think so, though. But anyways, it's a great comment, Ken. Jack Smith, if you look at these are very technical. You got to look at the appointment orders and see what the arguments are. In Merrick Garland's appointment, he used together a bunch of other statutes. They call them the Reno regs, and there are no statutes for a special counsel. There is a special attorney, but not a special counsel statute, which is what they said he was. And so that's what that got dismissed on. Rick D. Yeah, Senator Ruby Gallego went on CNN and admitted that the video calling on military to refuse illegal orders was actually the second video. He didn't get the script for the second version in time to record it. Yeah, Rubin also posted a video today. He drops the F-bomb in it like 4 or 5 times in the video. I was going to play it because he's an Arizona senator, but he's just F-bombing. It's crazy. These people have a potty mouth, and he sounds just pathetic. Ken loves America. Durham was an active Senate-confirmed U.S. attorney when he was appointed as special counsel. Right. Proper use of 515. Appointment of Deputy AG Blanche, then afterward resumed as DAG. Yeah, Durham was a U.S. attorney, right? And same with the guy who investigated Hunter Biden. David Weiss, I think was his name. So they were active U.S. attorneys who just got appointed to be special counsels. That was not Jack Smith. He was not ever a U.S. attorney. But I'm not sure that 515 requires you. So I think we might be conflating terms. Special counsel is different than special attorney. Special counsel is what they use the Reno regulations to make Jack Smith basically have his own office. Special attorney is actually defined in Section 515. And there's a lot of phrases: interim attorney, acting interim, acting attorney, interim attorney. So we just want to keep those straight. But Ken, I love the specifics on it, but that's how I remember it. Milan, Comey cuckoo for Cocoa Puff Nuts. Why is he so creepy? That's like narcissism just emanating out of his pores in those cameras. I didn't need to diet when he speaks because I feel sick to my stomach when he talks. Well, that's because you're watching a liar lie to the screen, through the screen to your face. Londo says, I finished the custom Tesla charger, battery powered solar charge, full rack battery charge, charges 40% of the car battery in 3 hours. More than enough for the nightly use. Man, that looks like some serious surgery going on over there. How many gigawatts is that? It looks like 1.21 gigawatts to me. So be careful. Hey, what's up? The O guys. What's up, the O guys? Those guys are great. Those might be my favorite Muppets of all of them. O guys says the Supreme Court is so limp. They need TRT to get to get their energy up. What kind of comment is this? Is this old guy? Pure evil. I can't read that. This is a family show. This is a family show. We can't read those things talking about whatever that is. The Common Nerd. What's up, the Common Nerd? Hey, thanks for rating our stream. That's very nice of you. Shout out to the Common Nerd. Jay Marino. Remember that jury nullification is the rule in the D.C. Circuit and Eastern District of Virginia when any Democrat gets in front of them? It's called TDS, yeah. A fast trial and acquittal is the worst possible outcome. The best outcome, considering they will be acquitted, is for Comey and Tish to suffer on their own petard of process punishment and bankruptcy by legal fees. Bring on the appeals, yeah. There's going to be a long road ahead, I think. And the process in many ways is the punishment. And we said that from the beginning. I'm not optimistic that we're going to get convictions across the board. Like, are we going to get Obama indicted and convicted? A boy can dream, but practically it's a long shot. Oh, guys, what's up? Says a text from the constituent. Evil baby ending in the womb Democrats caught lying and people still vote for these demons who go to the parties where kids are on the menu with Epstein. Evil. Says, oh, guys, good to have you there. What's up, Liz? Hey, what's up, Liz? Could you please give a huge shout out to lawyer Good Logic, who has now changed his start time to follow you? Stay people to listen. He is fabulous. Yeah, shout out to Joe, Good Logic over there. We're going to redirect over to him. And hopefully you enjoy the show. I think he's going live right after we're live. So check it out. Thank you, Liz. Thank you for the dono. Shout out to our friend Good Logic. Right next door on all the tubes. S. Quinn says, late getting here today, so forgive me if you've already covered it. I understand Comey case dismissed without prejudice, but isn't the statute of limitations out now? How does that work? He gets off scot-free? Well, we broke that down a lot. Yeah. So I just hit the rewind button on that, S. Quinn. We did a whole first segment about the whole opinion and decision. But yeah, my argument is he's got two options. One, you can appeal it and say that Lindsay Halligan was properly appointed. She should have never been disqualified. You can have successive 120-day appointments. It's the executive's power, not the court's power. So that the indictment comes back. It was valid from the beginning, which I think is an option, but also appoint a special attorney under, I think it was section 515, use the other section 2388 that says a dismissal of an indictment can come back if it's if it can be saved, which in this case you could argue it could, and then charge him again. Thank you, S. Quinn. Tim Jake, I was trained on not following unlawful orders several times while on active duty. The bottom line was you better be right when you refuse an order or you're going to get punished for failure to obey. From Tim Jake. Yeah, that makes sense. And you better hope that your decision to not follow an order doesn't get somebody killed or have a mission failure, because that would be a pretty big problem when you're having like a TDS moment because you just got done off TikTok watching Alyssa Slotkin. Says, oh, guys, what's up? The 6 senators need some cream. And that's because they're trying to incite a military coup d'etat. Yeah, well, they try to incite lots of coups. Says SCOTUS needs to TRT to increase their testosterone. That's also true. Oh, guys. 28 U.S. Code 515 allows the AG to appoint a U.S. attorney outside their district to conduct legal proceedings outside the jurisdiction, not necessarily for special counsel only. That's my point. Use the deputy AG. Says using an active Senate-confirmed principal office via 25515 to prosecute in Virginia temporarily removes the excuse the attorney isn't Senate-confirmed. It's an airtight appointment from Todd Blank. So I see what you're saying. Yeah. So in other words, use a U.S. attorney, right? Use somebody who's already appointed to do it, to make it even that much more solid. Yeah. Great points from Ken Loves America. We love America too, Ken. Thank you for that. Thank you for being here and for those comments. Quadcam shared this quote from Jefferson. The seeds of our government's dissolution lie in an unchecked federal judiciary, quietly expanding its power step by step until the states are overshadowed. Yeah, it's the tyranny of the judiciary. And everything can be done in the name of democracy, or in the name of racism, or in the name of equality, or in the name of due process, which they don't even know what it means. But my friends, thank you for sending those in. Great comments, great donos. Thank you for supporting us and for the great ideas and thoughts. Let's say what's up to our friends over on X before it's after party time. We got a couple of comments over here. What's going on? Neuro D says, join as a membo over on Locals. Thank you, Neuro D. Look at my face. How irritated I was making the thumbnail today. OTR, make sure you all hit that button and share. Got to hit the rewind button for sure. Jody, are you all watching The Watchers? Man, I hope so. Lisa Ann. What's up, Lisa Ann? Rules for thee, but not for me in the house. Rules for thee, but not for me constantly. And Catherine Rex. What's up, Catherine? Sharing some photos of the pup in the house. Couple of photos of the pup from Catherine Rex. And Catherine, your GoFundMe is getting linked under the spam, probable spam. Oh, man. Says, with sad news, I have to share that he has the C word. He's doing great. His mommy will not stop fighting for him. GoFundMe. You can donate to Rowdy for oral surgery if you want to help a pup with the C word. Over there on our X feed, you can just hit the under the probable spam. Go grab that. And if you want to give her some love, Rowdy would appreciate that. No doubt about it. All right. So my friends, thank you for sending those in and for those great comments. It is now time to head on over to our members only after party. We're going to debrief, hang out a little bit with our membos, see what else you have to say, take some Locals comments, and wrap it up on the night. But it has been a beautiful stream. We're kicking off this week. It's holiday week. We're very glad that you're here and with us, hopefully getting ready for a feast. But we'll pause for the evening. Before we wrap it up, I want to thank our amazing mods and meme smiths. Big shout outs to Donut Mind Me, to John in the house, Muffin Rando, K Bean, Carrie B. We got Neuro D, Janik, Dog Digger in the house, G-Gum, Gigum, Elliot, and Just Rhonda, all modding the fort down for us, keeping things nice and orderly around here. My friends, very glad to have you. Thank you for subscribing to our channel if you haven't already done that. Thanks for liking the video on the way out, but we'll pause here for the evening. Of course, we're coming back tomorrow to get into it again, and in order to do that appropriately, we are going to need to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very well. We'll see you right back here tomorrow. Bye-bye.
Thanks for watching, my beautiful friends. Now it's that time where the stream must end. You brought the heat with every chat and line. Together we expose corruption. One more time we dove in the truth where the media hides. Lit up the lies with receipts on all sides. The fight isn't over, but we made them sweat. We ain't done yet, no, not just yet. 'cause together we are watching the watchers, truth on our side. Watching the watchers, we won't be denied. Watching the watchers, eyes open wide, fighting for freedom with nothing to hide. Drop a like and don't forget to share. And bring a friend who's ready to care. Tomorrow's lies are just today's news, but here we see through the scripted ruse. Together we are watching the watchers, shining the light. Watching the watchers, defending what's right. Watching the watchers, stay each night together